Hello, I'm Amanda Weaver and I'm a solicitor at Newley Solicitors. I've named this talk this morning, Getting Your Ducks in a Row, as I'm hoping to give you some advice to put yourself or others in the best financial position in terms of relationship with your partner or spouse. I act for a number of clients who go through some difficult cases, and at the end I like to give them some help to educate my client on what to do next time to hopefully avoid any further legal wranglings. And so this talk is to give you that benefit without you having had to go through the upset in the first place. So I'll talk through how best to protect your financial position in terms of your home, your assets, and avoiding debts. And I'll go through a number of scenarios to explain this to you. So first, let's look at unmarried couples. A lot more people now just live together without marrying, which all seems fine. Until the relationship ends, and then it can get tricky and thus costly. Let's look at first the girlfriend owning her own home, and then she meets Mr. Wonderful and he moves in. He helps pay the mortgage, may put up some wallpaper or take out the bins, but after a few years the relationship breaks down. The boyfriend then might claim that he has acquired a beneficial interest because he has helped to pay the mortgage, and he then claims he's renovated the house. What the girlfriend should have done at the point of the boyfriend moving in is think about having a living together agreement, which sets out who pays what, but more importantly, it makes it clear that the boyfriend does not acquire a beneficial interest, regardless of what monies he pays towards the mortgage and any renovation costs. Still on unmarried couples, let's then look at if the girlfriend moves into her boyfriend's home, which he owns in his sole name. She contributes towards the mortgage, and at this point she should think about having her own name added to the title deeds of the property so that the property is owned in their joint names. Let's say the house needs a little bit of work doing to it, and she might offer to share the costs. At this point she should ask herself, why is she paying to renovate a property that she does not own? She'd hopefully then conclude that she doesn't need to contribute towards the property, or if she is going to contribute a significant amount, then she has a declaration of trust drawn up, and this sets out the amount that she's contributed so that in the event of the relationship breaking down and the house being sold, then she gets those monies repaid to her. Let's say she does contribute and she pays towards various improvements to the home, but sometime later the relationship ends and the boyfriend wants to kick out the girlfriend. As the property is in his sole name, then yes, he can ask her to leave, as she's living there under a bare license, and he would need to give her notice to leave, but that notice can be as short as 28 days. If the house were in their joint names though, then the boyfriend could not ask her to leave, as the girlfriend has a right of occupation. She too could have acquired a beneficial interest, but these cases, as I said a moment ago, are tricky and thus costly, so she may not get back, if any, the money that she has put in the first place. So to conclude, to avoid this, unmarried couples should think about having a living together agreement, or they discuss whether they change the house ownership to jointly, or the non-owner should not pay for any renovation works if they think they are going to get their money back, as they may not. So the relationship is going well and marriage is on the cards. You might then think about a prenup. At the moment, a prenup is not legally binding. However, the court will take it into account in any subsequent divorce proceedings and will add various weight to it depending on what factors have been taken into account when drafting it. But first, it's important to consider whether you want a prenup or in the first place or not. Let's say the wife-to-be is wealthy in her own right. She owns her own home and she's financially comfortable, but then along comes Mr. Wonderful, who is not so wealthy. In this case, the wife-to-be should consider a prenup to protect her premaritally acquired assets. Let's say the wife-to-be is not so financially well off, but Mr. Wonderful is wealthy and is likely to stay wealthy, i.e. he's not going to lose it. Then the wife-to-be doesn't necessarily want a prenup because she would want to have all of the claims available to her in any subsequent divorce proceedings rather than being restricted to what was said in a prenup. So they're now married, all is going well. This means that the family home is owned jointly and both parties are involved in the financial finances, so they would know who the mortgage, each party would know who the mortgage lender is, what bank accounts each have, and the balances in those accounts and whether they are in their joint or sole names. It is sensible to both stay involved in the finances rather than leave it to your spouse. And if you accrue savings that you consider to be joint, then they should be in a joint account rather than your spouse's sole name. There is also such a thing called a postnuptial agreement, which is not so common, but couples do have them. They are the same as prenuptial agreements in that they set out what would happen in the event of a divorce, but they've been drafted after the marriage. And the same considerations apply as to those taken into consideration in a prenup. So then all is not well. There are arguments and the wife is not sure whether she wants to separate or to divorce her husband. It would be sensible for the wife to get advice early on so that she knows what her options are. She would be advised to check that the family home is in their joint names, or if it is in her husband's sole name, then she would be advised to register her matrimonial home rights, which you can do so free of charge at the land registry. I would ask about the joint bank accounts and any overdraft facilities there are and what other debts there may be, and check that no further debts can be run up in her sole name. Are there significant assets in her husband's sole name that she has concerns that he might spend or give away? And do we need to take steps to prevent the husband from disposing of those assets? We would also talk about a will and explain the laws of intestacy if she does not have a will, and whether she would want her assets to be dealt with in terms of a will rather than the assets being automatically distributed if there's no will. So to conclude, we all work very hard and we want to reap the rewards of our own efforts. So really it's about protecting your assets and being sensible in terms of what your rights are, and also staying in the loop in terms of finances so that you know your own family situation. So if you have any questions or you are thinking of separation or divorce yourself, please do contact me. I'm Amanda Weaver and I can be contacted on 01788 555 042, or if you have a look at our website, moodysolicitors.co.uk, you can find all of our team's contact information. So thank you for listening today. Thank you.